Merry Christmas, baby. Reindeer's coming out to play. Santa Claus is packing the presents, making sure you've been behaving okay. Merry Christmas, honey. Yeah. The snowman's dusting off his hat, putting on the show for everybody, to give them a smile that lasts another year. There's something that happens when sleigh bells are ringing, when December ends, when the children are singing, yeah. It's Merry Christmas, baby. Ooh, yeah. There's room at the table for big and for small. All the fire is popping, the chestnuts are cracking, yeah. Merry Christmas, baby. Merry Christmas, baby. The snow is laying 2 feet deep. Now wish upon a falling star, so all your secret dreams can come true. There's something that happens when sleigh bells are ringing, when December ends, when the children are singing, yeah. It's Merry Christmas, baby. Ooh, yeah. There's room at the table for big and for small. All the fire is popping, the chestnuts are cracking, yeah. Merry Christmas, baby. There's something that happens when something that happens when December ends, when December ends, yeah.
Are y'all dancing? I am.
Oh, it's Merry
Little jive.
baby. Merry Christmas, baby. It's Merry Christmas, Merry Christmas.
Merry Christmas, baby.
Merry Christmas, baby. Yeah. It's Merry Christmas, baby.
Merry Christmas, everybody. How are we? Mark, Lori, thank you, honey, for your super chat. You're so kind. You're so sweet. And look, Mark's thrown out another 5 memberships. Mr. Big Casino Hopper over there. He must have hit the jackpot again. Speaking of Mark, so he sends me this thing on email, right? And y'all all know Mark. Of course, you all know Mark. He sends me this thing on email, and he's like, Carrie, take a look at this. So let me share this with you guys. Hopefully, y'all can hear me talking when I do this. I think you can. So he gets his female manager at the hotel I stay at this week. Mark, the manager you stay at this week, huh? Asked me what I wanted for my birthday. I said a blonde and a brunette, and this was on the bed when I returned later that night. That's adorable. Now, I'm not going to show the whole little letter she left you because it was very naughty. It was very naughty. But I'm assuming that you know this person well. And I would have to say that if they're that nice to go out of their way to make you laugh, that they must be some really good people, Mark. But thank you again for gifting the 5 memberships. I appreciate you so much. What became Eunice, where you been, Eunice? Girl, she said, what became of the hearing with Daryl Brooks and his ex-girlfriend Erica Patterson? Mama, let me tell you. Okay, so that thing keeps getting pushed back, and then he fired his attorney, and then he added. I'm pulling out my calendar here. Fired his attorney. or they quit, one or the other. We don't really know exactly what happened. And they assigned him a new one. So they were supposed to go back to court and appoint the new attorney, right? Last month. And when they got in there, they realized that no one had been appointed. So they've moved the next hearing for Brooks to the 14th, which is next Thursday, a week from today at 8:30 a.m. Pretty sure that's Central Standard Time. So we will be streaming it if he's there, if he's on it, if he's on stream, we're going to do it. We're going to do it. I'm just going to plan to have something that morning with all you guys. And so even if it doesn't happen, we can still watch a video. Okay? We can still watch a video together. But Eunice, it's so nice to have you. I don't think I've seen you in the chat before. I know. Where he has an attorney now. Yeah, the attorney got it. On the 30th, they assigned the new attorney. But there's nothing else on the docket. I checked it this morning. Hey, Miss Lady J. Or Lady Miss J. I'm sorry. He won't be on stream, she said. Well, he appears via Zoom. Apparently they're doing it, but they're not. There's nobody, like, I don't know why these people aren't showing it on their. I guess they feel like everybody wants to forget about him. I get that. Are y'all ready to do some hee-hee and a kiki-and? Thank you all for joining me and being here with me this evening. I appreciate you so much. I'm on about 10 cups of coffee, so if you hear any bouncing around, that's just me going around the walls, just bouncing off of them. All right, y'all ready? Ready? Here we go.
Is facing 76 charges, including 6 counts of first-degree intentional homicide.
And just into our newsroom, we've learned additional charges have just been filed against the suspect in the Waukesha Christmas parade tragedy. These are new charges from the Milwaukee County DA. Darrell Brooks is now accused of intimidation of a witness. The court documents show that Brooks repeatedly threatened and intimidated the mother of his child.
Trial may be delayed for Darrell Brooks. He, of course, is the man accused of killing 6 people and injuring dozens more during last year's Waukesha Christmas parade.
Brooks faces life in prison.
Darrell Brooks is supposed to go on trial here in October, but the defense team says that's not enough time for them to prepare. A judge will officially decide on Monday.
The man accused of driving his SUV through the crowd, killing 6 people and injuring dozens, faced victims and their families in court for the first time.
The vehicle made contact with me and I was pounding on the hood, yelling for it to stop. But as the vehicle continued pushing through me,
outbursts from Darrell Brooks in court today. He was asked to leave his own hearing. He's the man charged with the deadly Waukesha Christmas parade attack.
It happened just hours after he fell asleep and then lashed out at the judge and at sheriff's deputies in the courtroom.
My position changed to the side of the vehicle where I was directly outside the driver's side window, and I could see inside of the window and I could see the driver very clearly.
The court trying Darrell Brooks will meet to go over a questionnaire that will be sent to potential Waukesha County jurors to see if they can be impartial.
Brooks is expected in court today, and prosecutors say that this decision came after Brooks and his lawyers asked for a change in venue or for jurors in his trial, which Brooks's attorney said that the sheer number of people who were directly affected by the parade, along with what they call the powerful and passionate community response to the tragedy, makes it very difficult for the court to ensure a fair trial.
Multiple witnesses testified that a man they identified as Darrell Brooks came up to them after the Waukesha Christmas parade asking to use their phones to call an Uber. Those who lent their phones say he called his mother. Darrell Brooks continues to object to his name in the courtroom.
Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
A verdict in the Waukesha Christmas parade tragedy today. After weeks of reliving that horrible day in the courtroom, Darrell Brooks found guilty on all counts.
The 12 men and women found Darrell Brooks guilty of all 76 counts, including 6 counts of first-degree intentional homicide. He faces a mandatory life sentence for each homicide count. Now, the jury deliberated less than 4 hours to reach a verdict. Families impacted by the tragedy were emotional after that decision.
Darrell Brooks, case number 21 CF 1848. Appearances, please.
Zach Witchow.
Sir, state your name for the record, please.
I'm here as a third-party intervener in this matter. As authorized representative for my client, I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. And for the record, I do not consent to or agree to being called that name that you have identified here today.
Hey, Mama.
The record should reflect that the individual known to this court as Daryl Brooks is present in person in custody in street clothes, specifically a suit and tie.
Hey, y'all, give it up for Miss A and B. Hey, Mama. Good to see you. Thanks for stopping in.
And a mask. I just also want to make a record quickly that
If you guys aren't familiar, she has a channel too, and she does a lot of Brooke stuff. So, what is it? Auntie A and B Miracle B2? Is that how they find you? I don't consent. I don't consent, Mark. I didn't know what froggy meant until yesterday. I had no idea. I thought it was like a British thing. Girl. I am an enabler. That's all right. I'm an enabler. You want tough love? You want tough love? You go over to Beefy's channel. He quit doing them. He quit doing them. He said, tough love. I got to do it, Carrie. She said, this is my backup. Hold on. All right. Type it in, Mama, so I can give you a shout out for your channel. I resemble that statement. I resemble that statement. Take issue with that statement, Rhonda said. Lori said, I'm sure half of you guys are already, more than half of you guys are already subscribed to her channel. Hey, John Bubba. Hey, Cecilia. Hang on, guys. We want to get Miss Auntie's channel on here. What's her channel link? Put it up, and I'll put it on the screen. Okay. Let's get moving.
a number of documents were left by Mr. Brooks in the holding area just outside the courtroom. They have been put on his desk today. It's all of the autopsy protocols that were provided to him yesterday, the hard copies, that is, the diagrams that were presented in court related to those protocols, and a copy of the pretrial offer. So I just wanted to make that record. Hold on, not right yet, please. So I have been advised that all of the jurors are here and ready to go. I presume the state has available its next witness.
Yes. We do.
I just threw it up. I just threw your link
Exhibit
up.
162A into evidence.
As to 162A, Mr. Brooks, any position on that?
Yeah, I object. I haven't even seen it, first of all. And second of all, again, for the record.
Mr. Brooks, I'm just dealing only with the exhibit right now. Sorry for the interruption, but I need to do that without interruption from you. 162A was a screen capture that related to an annotation that a witness made. I believe that was during witness number 34. Yes, that was Mr. Hallmark. And so based upon that, Exhibit 162A is received, and I will so advise the jury when they come in. Sir, I'm not going to address any preliminary matters at this point. I've already addressed a number of things yesterday. The jury is to be brought out.
No, it was some things that needed to be discussed about the paperwork from yesterday.
We'll take that up on a break. You can look over it. You can make a note and pass it to
I've
my
already
clerk.
looked over it, Your Honor. With all respect, I think there's some things.
Mr. Brooks, I'm not going to deal with it right now. It's paperwork. I just wanted it notated that you left it, and now it's being provided to you again.
I'm not referring to that paperwork.
I'm not dealing with the paperwork from the clerk of court's office either. I am not the custodian. We're going to bring the jury out.
Okay, but she should know that she's trying to
Mr. Brooks,
get me to pay.
Stop. I am not addressing it.
It has to be addressed, Your
All right,
Honor,
I'm going to take a quick break and make sure the jury is ready. And
if I don't address it now.
Your Honor, y'all, the funniest part about half of these is that I just left it running when they put him on mute. Just let it go. All right, throw me out some of your best. I want to hear some of the best. Put y'all in a little competition tonight. Some of your best. Oh, hey, JPC. JPC said she just subscribed to Auntie. Good. I'm not going to ask again. I'm not asking again. I want y'all to type in the bottom of the chat or in the chat. It'll go to the bottom. I want you to type in your best one-liners from Brooksaholics Nation. Oh. It's a civil suit. I think the civil suit is my favorite too. Someone's being sued. It's a suit. It's sequestered.
No. I was told to pay for something under a civil statute.
Mr. Brooks, I am not the custodian. Bring it up with the clerk of court.
How
not
can I
addressing
bring
it.
With the clerk of court? How am I supposed to do that? So that makes me wonder if it's a
Mr. Brooks,
case.
the jury's coming out. I'm not going to address your request for open records. I'm not the custodian of the records, sir.
Being sued? My Sesty Trust is being sued?
Her Sesty question.
Mr. Brooks, this is an irrelevant matter that you're attempting to bring up in the presence of the jury. The record should reflect these interruptions.
Before the jury came out, Your Honor.
And I told you I wasn't going to address it. Please.
Okay, so it's a civil matter. Who's being sued? My Sesty Trust? Because how can I be
Mr.
sued?
Brooks, you're talking about an irrelevant matter between you and the clerk of court.
It wasn't irrelevant when I got the paperwork from the clerk of court. I was simply
Mr.
trying
Brooks,
to address it.
I'm not going to address it. The jury will
So
disregard
I'm being
these
sued?
irrelevant
This is a civil
comments.
matter? We haven't addressed subject
All
matter
right, thank you,
jurisdiction yet at all
everyone.
either?
Please be seated.
When all else fails, you throw in that big old SMJ. It's like salt.
Jury will disregard the statements Mr. Brooks is making about subject matter jurisdiction. They are a misstatement of the law.
Yes. No,
All right,
they're not.
and
just like this is a civil case.
Mr. Brooks, the jury's here. Please
Just like
show
this is a civil
respect
case,
and decorum.
According to this document, this is a
Mr.
civil
Brooks,
case,
please stop.
which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant
I have the
matter. I'm
paperwork
starting
sent
the
by the
trial.
paper course right here that says it's a civil matter.
Mr. Brooks
So
has
what's
nothing
being
to
sued?
do with
My
this
Session
case.
Trust is being sued.
I have no idea what you're talking about. So,
I got the paperwork right here.
all right, I'm
How
going
do
to
you not
excuse
know
the
what I'm
jury
talking
right
about?
now, given this disruption. All rise for the jury.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not gonna. This is.
You are not
I
being
was given
respectful
this
to
paperwork
this
by you, Your
proceeding
Honor,
or to
with
this
all respect.
jury. No,
With
it's
all
not.
due
With all due
respect,
respect,
with all due
stating that doesn't
respect,
make it
I was given
respectful.
this paperwork by you,
Mr.
from
Brooks,
Monica Paz.
stop talking till the
clerk of
jury
court.
is out.
Okay,
Thank you.
So why couldn't we address this before they came out?
I'm
That
not
was the
going to
time-
address it,
That
bottom
was the
line.
time to address it, though. We're supposed to do all the addressings before the jury comes out, before we start the matter.
Please
I
be
was trying to
seated.
simply address paperwork that was given to me by you, Your Honor. That states that
Mr.
this-
Brooks,
it states that
you
this
have
is a
interrupted
civil
me
matter.
repeatedly. You are on the verge of being removed to that courtroom. I don't want to
On-
do
on
that.
what-
I want you to stay here.
on what
But
fact of the
you
law, Your
keep
Honor?
interrupting me and bringing up irrelevant matters. I told you yesterday, as a courtesy that was provided to you, so that you would frankly not complain that you didn't get it as quickly as possible. Okay, I am not the custodian of the records. If you have an issue with what was provided to you, how it was provided to you, then take it up with the clerk of court.
can't
But
charge
from
me.
now on, I am not going to be the messenger and give you documents that you request to the custodian of the records or from the custodian of the really have to be delivered to you at the jail. But that is in response to your discussion or whatever we want to call it this morning. I'm not taking it up.
They need to get the chocolates out. Bubba says that we could sell tickets. Was it Tony, Bubba, or Mark that said we'll sell tickets and make $50 a piece?
All right, it is irrelevant.
Who gets to push the button?
It needed to be noted for the record.
It doesn't
Because
need
it
to be
was-
noted, sir.
You
All right,
gave
the
it to
jury's
me-
coming
you gave
back
it to
out,
me in
and I'm
open
going
court.
to warn you, if you bring this up again, I will pause and I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive, and for bringing up irrelevant matters in front of this jury. You will forfeit your right to be present for the direct examination of this witness.
I object to that.
Did you
Your Honor.
hear what I said, sir?
No, I did not. I object to that, Your Honor.
Well, you can object, and your objection is noted, but if you
For the
interrupt
record-
when this jury
for
comes
the
out,
record-
they will go, I will have them taken out again, and you will be removed to the next courtroom.
You can't, what is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the
And-
other cases that
and it
I've
doesn't
cited
say
previously.
anything
I'll
that-
make the appropriate record. Stop interrupting me. The jury's coming out. We're continuing with this trial despite your repeated efforts to disrupt.
That's a
Yesterday,
mischaracterization
sit
of the
down.
record.
Yesterday alone, sir, 17 interruptions, not including the opportunity that I gave you where you spent 50 minutes, okay, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't
And-
verified by proof any of what I
And
said,
none
Your
of that
Honor.
is required, sir.
Because it
And
is. You can't verify
your
with proof.
belief
Where's
that
the
that's the
subject matter-
law
where's the subject matter
doesn't make it
jurisdiction?
so, Mr. Brooks. Your belief that these are legitimate legal positions
They are.
doesn't change the law and doesn't make it so.
It's
So,
clearly
again,
relevant because you didn't want to.
I'm
address
going
it.
to step off and give Mr. Brooks 5 minutes to cool off,
I'm
and
not-
when that
I don't
happens,
need
I'm
to
bringing
cool
the
off.
jury
I'm
out,
not angry at all.
and then we will
I just wanted
continue.
to. I don't.
Melanator said her blood pressure is already rising. You feel it coming up, huh? He did, so he had to pay for all that stuff. Is that what it was about? He wasn't paying the court for the paperwork he had requested, and he wanted it certified, time-stamped, and he wanted it then and there. Oh, and he wanted the original. He wanted the original. I'm not a person. I'm a living, breathing human being. That's right, Bama. He likes to re-examinate. I'm looking at all y'all's little things here. How am I in dishonor? Oh my gosh, I remember I did a whole video about the dishonor, but I don't know if I got it somewhere. I thought what we would... I forgot I have my thing on. I thought that what we would do, you guys, is go over some of my old videos at some point. Certified copies cost money. They are not free. That's right, Coffee Cake. All of a suddenly. What was the other thing that he said? Oh, he just said it the other night, y'all. It was so funny. It wasn't suddenly. It was about that same time he said that. Give me all the jurisdiction, judgy, full of subject matter, saying
Thank
you're
you,
gonna
everyone.
remove
Please be
me
seated.
then, but I ain't seen nothing. That's one of John Bubba's tunes.
Good morning.
What else do you all
Oh,
recall
it's
that you
chilly
can't
in here.
remember?
It's probably they adjusted it. We'll need to call them and tell them to bump it up a little. Now that the weather's changed. No, I would find out what the temperature set at. It's cold.
Coerced. That's right, Lori. That was the other one.
It's definitely like an ice box in here.
Am I muted? The funny thing is, when I say that, some of you guys will type in there, no, you're not muted,
All
Carrie.
right, good morning, everyone. Court will call State of Wisconsin versus Daryl Brooks, case number 21 CF 1848. May I have the appearances, please.
Yes, good morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
Good morning, sir. Your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
All right, the record should reflect that the individual known to this court as Daryl Brooks is present in person in custody in street clothes. He is wearing a suit, I believe a tie, can't quite see around the monitor, and a mask. Your objections noted for the record. The appearance, as I've just indicated, stands. I do want to advise the parties today that one of the jurors called in this morning and was not feeling well, and I did excuse that juror. So that will mean at the appropriate time, when the court selects the alternates by random lot, I will only be selecting 3. I believe that was juror number 35. All right. Anything preliminary before the jury's brought out for the continuation of testimony from the state?
The jury deserves to know.
Is the audio on, Your Honor?
No.
Okay, thank you.
All right. Sorry about that.
The only thing, housekeeping to clean up, Your Honor, is Exhibit 15, which was the victim map that we had first introduced through Detective Casey, and you admitted it subject to proof of all of the events that are depicted on the map. We believe we have now reached that point where it can be admitted in full. I do have a poster-sized copy of that exhibit that's also marked as Exhibit 15. So we have Exhibit 1 is the map of the downtown area. Exhibit 15 is the what we have termed the victim map, or the parade victim map. That's a hard copy of that as well, and then I have a third one that I'll be introducing later today or tomorrow. But we just wanted to clear up on 15 that all of the information on that map has now been testified to, Your Honor.
I did admit it subject to the full foundation. Any position on that, sir?
To it being admitted?
Yes, fully received. I had received it subject to foundation, and the state's set forth its position. Do you have any position on that?
Yeah, I object to it. I don't see the relevancy.
Of course he does.
All right, your objection is noted, and Exhibit 15 is received. I believe I told the jury it was received subject to that foundation, but I will advise them that it's been received by the court when they come out today.
My favorite is when he says, I accept for value and return for value the paperwork that I have not seen.
All right, and then one other housekeeping matter. Last week, I believe it may have even been on Thursday, we had a discussion with Mr. Brooks outside the presence of the jury in which several broad topics were discussed. One of them was Mr. Brooks had indicated he did not have a pretrial offer from the state. We would ask the record to reflect that afternoon we did provide him again with a written copy of our pretrial offer, and that was placed with his materials on the table. I just wanted that in the record, please.
I object to that. I don't. If it was with my paperwork, I haven't seen it.
It was specifically one of the papers, sir, that you left in the bullpen area that on the next morning, on Friday morning, I made a record of providing back to you. So it was provided to you twice.
Well, I haven't seen it.
You want to put the offer on the record, Attorney Hopper?
Give me 1 second.
Here it comes.
So what's the significance of it being on the record if
so that you are fully aware of it, sir. It was provided to you, but you're indicating you haven't read it, so I want them to make a record of it. The significance would be, I suppose, if at any point you wanted to change your plea, you could do that based upon the pretrial offer.
Well, in any event, I accept for value and return for value that document whenever I see it.
Attorney Hopper, go ahead.
Sorry, it's just taking me a second to retrieve it here, Your Honor.
Your Honor, this would be a perfect time to address the subject matter jurisdiction that has yet to be proven on the record and must be
Mr.
proven
Brooks,
by the prosecution.
we are not going to address that. I issued a written decision last week. If you disagree with that, then you can take that up to a higher court. But I issued a written decision. I'm not addressing that any further.
It has yet to be proven on record.
Mr. Brooks, my written decision is the decision of this court.
Has it been proven?
Go ahead.
Has it been proven on record that you have subject matter jurisdiction? Because it has yet to be proven.
Mr. Brooks, your position is simply not correct as a matter of law. I explained that,
Then prove it
and I
lawfully
issued
by
the
law.
decision. You might be confusing subject matter jurisdiction with venue, which is why I commented on that last week.
Absolutely
And
not.
there has been evidence received regarding venue. So I'm going to turn back to Attorney Hopper. She's going to make a record of the pretrial offer. I'd ask that you not interrupt. Thank you.
Your Honor, the offer that was dated July 5 of 2022 reads as follows. Plead to counts 1 through 67 in the information. The penalty enhancers on all counts will be struck. Counts 68 to 83 will be dismissed and read in. The state will recommend 6 consecutive life sentences on counts 1 through 6. The state will recommend unspecified prison on all other counts. The defense is free to argue. This pretrial offer was conveyed to his prior counsel on or about the July 5th date, and there in fact had been a earlier offer as well that had been relayed prior to the preliminary hearing or the filing of the information back in January of 2022 that had also been conveyed to his defense counsel at the time.
All right, thank you.
So why haven't I been informed of that?
All right, Mr. Brooks, that is not a topic we are going to take up any further. I just wanted the record to reflect that offer was conveyed to you.
It wasn't conveyed to me, Your Honor. This is the first time I'm hearing of it. So if it was conveyed to my former counsel,
it's not something I'm going to further address, sir, unless you indicate to me that you would like to take advantage of the pretrial offer by changing your pleas to either guilty or no contest to counts 1 through 67 and submit the appropriate paperwork. I'm guessing that's not what you want to do. So unless that paperwork were to be filed, then I'm going to continue with this trial as if you are exercising your right to a trial in this matter.
and in all respect, Your Honor, I don't think it's fair that you should assume what I want to do or not, or what I don't want to do.
Lord.
I just need to make a record that that paperwork was provided, sir. We'll continue with the testimony today. I'm not going to take up subject matter jurisdiction. I've issued a written decision. Is there any other preliminary topic from either party?
Is that decision verified proof that subject matter jurisdiction exists? Because it has yet to be proven on the record.
All right, your objection is noted. Please bring the jury out.
Did any of you guys write SMJ in the chat yet? I don't think you did. We're just so used to hearing it.
Your Honor, is that
I'm still
the answer?
for it.
Mr. Brooks, I issued a written decision. That's your answer.
And what's that? And what does the written decision entail?
So that was provided to you last week. I'm not going to
I accept for value in return for value the document that I have not seen. What does it entail, Your Honor?
Sir, you were provided with a written copy. I'm not going to read it into the record at this point. It is part of the record. It's a final order
If
for
it's
purposes
part of the record,
appeal.
why can't it be read into the record right now?
It doesn't need to be read into the record, sir.
Is it
It's
verified
part
proof
the
of?
record.
Is it verified proof of subject matter?
Mr. Brooks, I'm not answering that because it's not something that needs to be verified.
It has to be verified by the prosecution. Or is that a tacit agreement that you don't have to answer that question or verify proof of subject matter
Sir,
jurisdiction?
I have no such agreement with you, tacit or otherwise. So that's not how this operates. Again, just
So
because
would
you
it be
believe
proven?
the law requires, that doesn't make it true. All right, the
Show
jury's
me
coming out.
lawfully
All
law.
eyes for the jury, please.
Show me by lawfully law that you have subject matter jurisdiction, because it hasn't been proven on the record. It has yet to be proven for the record. Let the record reflect that.
The record will not reflect that, and the jury will disregard the comments currently being made.
The record
just
should
made by
reflect that.
Mr. Brooks.
You have to put it on the record. Otherwise, that'd be tampering with the record. So at 8:40.
All right. Good morning, everyone. Please be seated.
Tacit agreement at 8:40.
All right. Please disregard the most recent comment by
Tacit
Mr.
agreement
Brooks.
at
It's not
8:40.
evidence in this proceeding. All right. The statement call its next witness.
Thank you, Judge. The state calls Sean Backler.
No subject matter jurisdiction.
Jury will disregard that last statement by Mr. Brooks.
Has to be on the record.
Good morning, sir. Please make your way to the witness stand, which is all the way up by me, to my
Am I muted? I was muted. Has anybody ever had a Jaeger bomb? It's one of those things where you take like the mug of beer and you take a shot of Jaeger and you drop it into the mug of beer and then you drink it really fast. So I've had like one of those in my lifetime, right? I swear, I bet the judge was dreaming that she could have one of those during this trial, like during the day. Just one. Just
right. When you
one.
get there, please remain standing, raise your right hand.
I didn't know I didn't clip it good enough. I guess I didn't clip it good enough. I was trying to make this go through real quick and smooth. It'll be just a moment, please. Please hold.
Thank you. Be seated.
Okay, thank you. I gotta get back to them. Okay.
I need my staff and then.
Fundamentally, Sonia, fundamentally. He's like, what they got going on over there? What the hee and a kiki-ing about? What they got going on? Trying to be slick. I see what you're doing. I see it. Ain't gonna work. I'm not stupid. Ain't gonna work. Come on, man. Come on, man.
All right, good morning, everyone. I will get started. I will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge Sue Upper, Leslie Basie, and Zach Woodshaw appearing for the state of Wisconsin.
Good morning. Good morning, sir. Please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any other facts in the charging instruments.
Record should reflect that the individual known to this court as Darrell Brooks is present in person in custody in street clothing, wearing a suit and tie and a mask.
For the record,
today.
I do not consent to being called that name, Your Honor.
All right,
and we still have yet to address subject matter jurisdiction.
For those of you just coming in, we are going through all morning sessions of the Darrell Brooks trial. We are currently today watching mornings 7 through 10, and yes, 7 through 10 takes up 2 hours for these morning sessions.
The court has addressed it for the record. So
for the record, has it been proven?
Mr. Brooks, I stand by the written decision that I issued in this case last week. A second copy was provided. Please don't interrupt me. A second copy was provided to you. I know you saw it because you tore it up yesterday. So I'm not going to address it any further. You are mistaken and wrong about the law that it needs to be verified or proven.
Are you talking about the paper I accepted in return for value?
So with that, I believe, Mr. Brooks, I'm going to continue with this trial, whether you believe jurisdiction has been proven or not.
It has not been proven for the record.
And it has. So with that, Detective Carpenter was on the stand.
And it needs to be proven.
And I
per the prosecution
would like to have him brought back up unless there's any other issues the parties wish the court to address in the state.
I did want to address something briefly.
Go ahead.
As the court knows from our short discussions yesterday, the state will be playing a couple videos of the defendants and his statements. The court had previously heard those as part of a motion hearing, and I'm not sure if I'm really giving the defendant notice or what I'm doing, but I really tried hard, and I'm pulling out snippets from this because if the court recalls, there are a lot of references that the defendant makes to prior domestics with Erica, his prior record, things that the court had previously excluded. So I'm going through and I am pulling specific time ranges from this so that nothing that was previously ruled inadmissible comes in. And I guess, obviously, this defendant has the absolute right to cross-examine the witness. He has the right, and we've offered and we have been putting exhibits up for him. But I do want it to be noted that I would not be willing to have Mr. Brooks just say, oh, go to about the 7-minute mark, because if he even goes like 2 seconds before a clip that I had played or 2 seconds after, it could include information that was previously ruled inadmissible.
You guys see what they're doing here? They're trying to help him. Once again, they are trying to help him. They're going above and beyond what they really have to do, and watch how he responds.
And I guess what I would say to the defendant is the court has previously protected the defendant to make sure that things didn't come out, where he asked a question that could be construed as opening the door, and the court said, we're not going to go there, Mr. Brooks, and he got the message. However, with this, if there's any portion of this video that's played that talks about the prior with Erica, I do consider that he has opened the door, and I will be asking the witness about it. So I guess this is maybe more so directed at Mr. Brooks, that if he plays clips that contain that information, he will have opened the door. He's had this video for weeks at least. These videos have been subject to a motion hearing. I'm not sure exactly what access he had to them before. I've reviewed the 5-hour video a number of times. I've been very meticulous in my timestamps that I'm grabbing out from here, and I am unwilling to have the defendant put Ms. Gussie in a spot where he's kind of, well, around this point. He needs to give exact times that he wants started and stopped, because what happens is if he says, okay, can you pause here, by the time he says that, 5 seconds may have gone by, which may be enough to, some of these, if I would play 2 more seconds than what I have here, it would open the door. So I just want the defendant to realize that this is kind of a slippery slope here, and he proceeds at his own risk. And I'm not going to ask Ms. Gussie to stop it at a certain time because I think something's about to be said. That's on the defendant. And if he opens the door, I can assure you, I will go into it. So I did want to put that on the record, Judge, not to be a jerk about it, but just once it's out there, I can't not address it. And if it's the defendant who brings it out there into the view of the jury, then I'm going to feel compelled to address it. And then I didn't know if the court wanted to go through the preliminary instruction that you had provided previously on the interpreter. My understanding is that Mr. Marquez speaks very little English. If you want to add the added paragraph, that would be fine for the state. I've had 2 discussions with him, and I would not say he is, that English is a comfortable language for him.
All right, thank you. As to the first part, to what the state brings up regarding the redacted recording, I would remind Mr. Brooks the court did enter some rulings previously. Why do you have to roll your eyes at me? Let's start the morning off on a good note,
I didn't
sir.
roll my eyes at you, so I don't think it's fair that you should say I rolled my eyes at you.
I saw you roll your eyes at me. I'm not
I
going to
didn't roll
debate
my
about
eyes
it.
at you, so don't do that.
Well, Mr. Brooks, I'd appreciate a little bit more respect. These
I will too,
rulings,
Your Honor.
let me finish, because now you're interrupting me. These rulings were entered by the court to prevent other acts evidence from coming in, but a defendant can open the door in a variety of ways. These recordings, and I have reviewed them previously, do contain discussion and statements by you regarding these other acts. And as you heard from Attorney Basie, she has all of the timestamps to stop at appropriate times so that the state does not run afoul of those pretrial rulings. You can open the door by asking questions, by asking for a video to be played and not knowing those exact timestamps. I think it's important that I reinforce what the state has just advised you of, so that when you are watching the recording, as all of us will be, if there is something you want replayed and you want to cross-examine the witness about, that you know those time stamps. And then the state has graciously indicated they would assist once again in replaying portions of that video. I don't need a response from you unless you feel you would like to give a response to any of that.
With all due respect, they're the ones that want to play the video, so I don't understand how I'm the one opening the door. They chose to play the video, so
they're not going to play the entire video, though. They're going to redact out, probably stop, fast forward the portions that this court said would be inadmissible. So for example, if during your cross-examination of Detective Carpenter, you ask the state to replay a portion of the video and you say, go back to around the 7-minute mark, you have to understand that you may open the door, even inadvertently, to some of those other acts, evidence coming in. So what I'm telling you is, if you want any portions replayed, then, or if you ask for the entire video to be played under the rule of completeness, that you have an understanding that you would be opening the door to the evidence of other acts coming in. Potentially, I'll have to rule on it at that time. So be mindful of the timestamps.
I don't understand, and Your Honor, that's almost like you making a ruling and then it not having any standing. If you already made a
ruling, the ruling's against them. I told the state they can't offer this evidence.
Right, that's what I'm saying.
So if you offer the evidence or ask questions that would open the door, that's a different story. And we all have treaded lightly when you've asked questions that would have opened the door to a variety of witnesses. So the state's just simply saying, look, we're going to do our job. We're not going to put in the other act's evidence. We're going to pause the video, fast forward the appropriate spots. But if you want any portions replayed, or if you ask for the entire video to be played, then you do that at your peril of having those other acts' evidence come in. So that's all I want to tell you. As far as the jury instruction, do you have any position on whether that second, well, I shouldn't say second, it's the very last paragraph where it says, add the following if appropriate. Do you have any position on whether the court reads this entire jury instruction 60 to the jury prior to Mr. Marquez being called as a witness?
Yeah, I think the jury should hear whatever needs that they need to hear.
Do you have a position on that last paragraph specifically, sir, given the information that the state has provided today?
Last paragraph.
You don't know what the hell she's talking about.
It's in brackets and it's after a bolded section that says, add the following if appropriately. Advised the parties yesterday we would be talking about that this morning.
I can't believe he found it so quick in all them boxes that he hadn't been through.
I mean, it was just stated that witness doesn't speak very good English, and so that would indicate that it would be a lot more work for the interpreter to make sure.
That's not what I'm asking about, sir. I'm asking whether you have a position on whether I include the very last paragraph of that instruction to the jury.
No, I don't feel like that needs to be read to the jury. I think it's pretty clear from all the language leading up to that.
Let me ask Attorney Basie a question about the contact the Office of the District Attorney has had with Mr. Marquez. Were you able to communicate at all in any way in English, even if you would describe it as broken English?
Yes, I think our last conversation, we probably said, I said something in English, he responded, and then when I said something else, I think he needed translation for that. His primary, our victim witness person, specialist assigned to the case, is bilingual, and she speaks to him in Spanish.
All right, given that bit of information provided by the DAs and Office of the Court regarding his ability to answer some but not most, I think it's appropriate to read the very last paragraph. Certainly doesn't hurt. It's not going to take away. So I will read the entirety of jury instruction 60. Obviously the part that says read here if appropriate comes out, and then I will print that off, and that is what I will read at the appropriate time. Did that print, Madam Clerk?
Quick question on that. How do we know exactly what words the witness will be able to understand in English versus?
That's not how the interpretation works. The questions are in English, they're interpreted in Spanish to the witness. The witness will answer, presumably in Spanish, and then the witness's words will be interpreted in English, and it's the English, as this instruction says, that is the evidence.
I think it's a little unfair that prosecution has had conversations with the witness and I haven't, considering that it's my witness.
They were on the state's witness list as well, I believe. So it's fair for either party to reach out, and if witnesses want to talk to either party in preparation, that's frankly fair game.
So how would I be able to reach out to a witness?
Mr. Brooks, you are representing yourself. That obviously poses some challenges and difficulties, but that is the state and stage that we are at. So,
Chair, that's awesome. This is about the time the court recorder wished she worked at Target.
So with that, I know we'll get Detective Carpenter on the stand. He can come up and be out here when the jury comes out. So come on up, sir. I will swear you in again, as is my practice when there's a witness on the stand for a second day.
I have one more thing real quick.
Johnny Bubba.
Well, it needs to be other than subject matter jurisdiction, so what is it?
You didn't even let me get to it.
I said, what is it? I said it needs to be something other than subject matter jurisdiction.
Can I
What
get
is
to it?
You can say.
There's no way to know what I'm going to say if I can't say it.
Mr. Brooks, please tell me what it is you'd like to address.
I want to address why my ICFs have not been addressed, because I know you have them. Why have I not getting copies? I've gotten copies of every other ICF. Why not the recent ones?
Sir, I am not going to be the intermediary anymore for ICFs that are directed to the clerk of court regarding copies.
That's not explaining why I haven't.
I'm not the
even been
keeper of
told
the record.
if
So
they've
if there's
been
something
received.
you want me to address, then you should address your ICF to me and not the clerk of court.
Well, where is the ICF?
Sir,
if I sent it, I
I
should be
am
able to
not-
get a copy. I've gotten copies of every single one.
You need
whether
to
they were
ask
addressed,
for that from the clerk of
whether
court.
they were addressed to you or whether they were addressed to the clerk of courts. I've always
I'm not going to
been
address that
told.
further, Mr. Brooks. I'm not going to be the intermediary when
So
you
what's
have
the-
questions to the clerk of court.
So
for
what's the
copies
point of me
things
sending the
like that.
ICF, me doing what you asked me to do, and sending them, and then not being able to know if they've even been received and get a copy of them, which I've been getting
If
copies
you
of
did
them
not
ever
ask
since.
for a copy of the ICF, they don't have any obligation to
I
send that.
addressed it when I first sent it. I asked you on the record, did you receive it?
I bet all you weirdos know all this stuff by heart, don't you? You do. You do admit it. You do.
Mr. Brooks,
You
I
said-
didn't receive anything because nothing has been sent to me.
Well,
So
where's the
if there's
ICF?
something that you need, then you should reach back out to the clerk of
I
court.
shouldn't have to do
But we're
that
not
if I
going to
sent
take
it.
up court time regarding an ICF sent to the clerk of court. Again, I will advise you once again, I did this the other day, if there's something case related, it needs to be addressed to me. If it has to do with the record, it needs to go to the clerk of court.
And it was.
Because I am
sent to the
not
clerk of court.
But
I still should be able to be told if it was received and get a copy, which you've done that before every single ICF.
And I told you I would no longer be doing that, sir, because of this very issue. It
so
takes
you saying
so now
it changes? So now it changes all of a sudden?
No, it didn't change all of a sudden, sir, and you know that. So don't try to confuse the record.
Does it change all of a sudden?
All of a sudden,
because I've been getting copies of everything I've sent, which is what you asked me to do.
This changed last week, and you know that.
It shouldn't change.
So
no, I don't know it.
I'm bringing the jury out, and I'm not addressing this issue.
So I want the copy of my ICS that I send.
Send a request to the clerk's
office. I don't have
office.
to send her another request. Where's the one that I just sent last week?
All right, the jury is going to come out, so please be respectful.
I will, but at the same time, you still have to. I did what you asked me to do.
I did.
If you tell me to do something and I do it, and then now you're saying I'm not going to get a copy, which you've been providing them ever since you told me to do it.
Mr. Brooks, the rules on that changed last week.
No, it did not. I'm still supposed to be able to say if it's been received or not. So,
Auntie, he reserves all his rights as a citizen, as a sovereign citizen. That's what I was trying to say. He reserves all his constitutional rights as a sovereign citizen.
Why should I have to send multiple ICFs to even know if they've been received? That's ridiculous, Your Honor.
I'm going to give the parties the final version of jury instruction 60, which I will be reading at the appropriate time.
Come on, you can't change stuff at the last minute. You asked me to
Mr. Brooks,
do something.
I did it as a courtesy, and frankly, you're not courteous to me.
I'm not even
The
referring
record
to
should
that.
reflect that the jury is coming out.
I'm referring to the fact that you haven't even had enough respect to tell me it's been received.
Please be respectful to the jury. They're coming out.
Okay, that doesn't mean that you shouldn't be able to tell me if my ICF has been received. ICFs that you told me to submit. You told me that.
Ladies and gentlemen of the jury, you will disregard the commentary by Mr. Brooks.
I accept for value and return for value this document. Just like you've been hiding everything from the jury that they need to hear.
The jury will disregard. The court is not hiding anything from the jury.
Yeah, you are.
So,
yeah, you
Mr. Brooks, please be respectful.
You should be respectful.
You are
me
addressing
to do.
issues that are not related to evidence
in
this case.
You asked me to do
Mr.
something,
Brooks,
I do it.
Please.
And then now it changes.
Everyone can be seated. Thank you.
This is ridiculous. Just like subject matter.
I'm surprised he didn't call Marcus and old girl Stephanie to the stand.
The jurisdiction hasn't been proved. Just like you're making judicial determinations that you don't have to prove anything by law.
Hold on.
Which is a tacit agreement by you, Your Honor.
Ladies and gentlemen of the jury, please disregard the statements currently being made by Mr. Brooks.
Why? Because it's true.
Incorrect statements of the law. They
then prove that they're incorrect. Prove.
In this case.
Where's the proof? Where's the legal proof?
And you need to disregard them.
Because you don't have it.
And we are going to continue with testimony, Mr. Brooks. I warn you, do not interrupt.
I don't identify by that name.
We will have a discussion about whether you will continue to be here.
I don't consent to being called that name for the record.
Detective Carpenter, please stand, as is my practice when a witness is on the stand for a second day to be sworn in again. Go ahead, Teresa. Please raise your right hand.
Lie to the jury.
Do you solemnly swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. And just for the record, please state your name for day 2.
Detective Jay Carpenter, Jaycarpe.
Just doing the morning sessions for those of you just coming in.
Authorized representative for my client. I accept for value and return for value all of the charges in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not consent to being called that name.
The record should reflect that the individual known to this court as Daryl Brooks is present in person in custody. He is in street clothes, wearing a suit and tie and a mask.
I don't consent to being called that name, Your Honor.
I understand.
For the record.
And I have advised you previously that I will continue to refer to you at times by that name as I
love how she tells him at one point too, sir, everything we say in here is on the record.
I believe it's appropriate given the charging instruments in this case. And other evidence now that's been received during the course of this trial where I believe we are using the accurate name. With that, I
don't agree to that, Your Honor, or consent to that.
Your lack of consent is noted. So before we go forward, I need to put a couple of things on the record. I know Mr. Brooks has filed some things, but before I get to that, as I told the parties on Monday, I had excused one of the jurors for a health reason, and it has come to my attention that I now have a second juror with the same health concern. Out of an abundance of caution, I am going to bring the jurors out to question them about their, whether any of them have any concern about continuing to serve on this jury, given the health concern. I am referring to a COVID concern. I'm not going to ask any particular juror whether they've tested positive or not, or whether they've had an exposure. But I am going to ask them questions about their willingness to continue serving, whether it's interfering at all with their ability to pay attention. Out of an abundance of caution, we have brought in 2 air purifiers, although I am told that because of the new building and the HVAC that's in this building, and I received this from our facilities manager, the new HVAC system in the court's tower has a UV light system that disinfects the air at a higher air exchange rate than the purifiers, and that the system was specifically designed so that no special standalone systems are needed. But again, out of an abundance of caution, we've had 2 air purifiers put in this courtroom. I'm putting a 3rd one in the jury room. We have also provided jurors, should they wish, with masks. We've increased the hand sanitizers and the disinfecting wipes. We've always had the hand sanitizers around. There's one on the jury box at the moment, and they've been in the jury room. I'd also like to put on the record that I did advise the jurors on Monday that one of the jurors was not going to be with us any longer due to a health concern. I asked them at that point if anyone had any concern. I did indicate at that point it was a possible exposure, and they all indicated no, they didn't have any concerns. But again, out of an abundance of caution, I feel it's important to now question them while they're in the jury box to ensure that there aren't any issues related to that. So with that, I am going to instruct the jurors to be brought out for that purpose. And then they'll be excused after that so we can continue the discussion regarding that, and then deal with, if need be, the other issues.
I think this is the part where he shows concerns for others' lives. I'm not sure, but I'm pretty certain this is where he pulls that.
And filings that have been brought to my attention today.
Your Honor, will we be addressing subject matter jurisdiction?
No, not at this time.
Still has yet to be proven for the record.
I don't know if the audio is on, but.
Am I muted?
All right for the jury.
Could you have a microphone available, please, if need be?
It wasn't just that anti-B. It was when he said the stuff behind it. I was like, really? To live by the book? That actually came out of his mouth. To live by the book.
Wait, if you could bring me that. Michael, can I hand you this? We're not going to take testimony at the moment. This is preliminary. Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, I brought you out here. We are not taking testimony at the moment. I have made a record previously regarding COVID-related concerns with the jurors. I know you are all aware that one juror was excused due to a health concern. I also put on the record that on Monday, when I advised the jurors of that, I asked you all if anyone had a concern regarding that, and that no one indicated they had a concern. I have been made aware of a second issue and potential exposure. And so I wanted to make a record in open court and to ask each one of you if any of you have any concerns about continuing your service in this case due to exposure to COVID. And so I'm just going to go through each one. Hopefully I can see all of your numbers from here. I'll just start from the back row and move from my left to right, front row, my left to right. And I also want to let you all know we have a very, very good HVAC system. I made a record of this while you were not here. But this is a new building. It has brand new technology. I've been told that the HVAC system in the courts tower, and this was told to me by our facilities manager, has a UV light system that disinfects the air at a higher air exchange rate than purifiers, but out of an abundance of caution, I've had 2 air purifiers also put in this courtroom, and I've had 1 put in the jury room. I believe you would be able to confirm for us as well that when you got into the jury room this morning, there were extra sanitation supplies along with masks. And so with that, I am just going to identify you by number. First of all, juror number 11. Do you have any concerns about continuing your service in this case, specifically related to COVID?
No concerns.
All right, thank you. Let me actually go back to, would the fact that you may have been exposed in any way interfere with your...
Y'all are talking about wine, and y'all, I'm that far back in the chat. I guess it's just not popping up. The chat's really slow on my side. We're talking about alcohol. You guys, yesterday we were discussing the fact that those attorneys that originally were going to defend him, that got out of there and left skid marks on the dad blasted floor when they left. They were sitting at a bar doing shots, watching the trial, and every time he said subject matter jurisdiction, they did a shot. I'm convinced of it. Somebody said they dodged a bullet. I can't remember which one of you guys said that, but that was dead on.
Ability to pay attention and ultimately render a verdict in this case.
No.
All right, thank you. And then let's see. I know our bar is really. Juror number 48. If you could also answer those 2 questions.
No concerns, both ways.
All right, thank you. And then juror number 46.
No concerns.
Thank you. Juror number 34.
No to both.
Thank you. Juror number 27.
No, also to both.
Thank you. Juror number 30.
No concerns to both.
Thank you. Juror number 1.
No concerns to both.
Thank you. And then what's your number? 6. Juror number 6.
No concerns for both.
Thank you. And then juror number 14. I'll just start there.
No concerns to both.
Thank you. Juror number 10.
No concerns to both.
Thank you. Juror number 51.
No concerns to both.
Thank you. Juror number 45.
No concerns to both.
Thank you. Juror number 19.
No concerns to both.
Thank you. Juror number 41.
No concerns to both.
Thank you. And juror number 3.
No concerns to both.
All right. Is there anything I haven't asked of the jurors or any other concerns related to that you would want to bring to my attention? If so, just raise your hand. There are no hands raised. I can also tell you from our initial days of COVID, when we started up jury trials, we do have plexiglass panels that I could put in between anyone who would want one. Is there anyone here who would want that? If so, raise your hand. No hands are raised. That's really all I have. I don't know if there's anything either of the parties would want. Need to ask the jurors from the state on this topic. All right, Mr. Brooks?
No.
All right, thank you. I'm going to excuse the jurors then, and then when we're ready, we'll have you brought back out. And thank you so much.
I don't like the way he looks at the jury. If I was a juror, I'd say something about it. He has multiple letters. He has multiple letters and none of them are signed. Not one of them. You've obviously never been in prison. Obviously. I'm gonna step out on a line. What is it? I'm gonna step out on a branch here. What did he say? You've obviously never been in prison.
Thank you. Be seated.
Judge, can we ask you a question?
Go ahead.
We counted 15 jurors in the courtroom.
I excused one.
You excused one earlier in the week too, though.
No. I'm only talking about the one. The other one I didn't excuse.
I see. Okay.
And thank you. I'll make a record of that. I did not excuse given when that person reported their symptoms and where we're at today. So it would be.
So that person is here.
Yes.
And willing to continue serving.
Yes.
Okay. Thank you.
Sure. And I will make a further record that none of the jurors are wearing masks. And I'm not going to mandate. I believe it's a personal choice. And that would also be consistent with, I believe, our county policies as well. So, unless there are anything related to that, I have a couple of other issues I need to address this morning.
I got something for that.
Oh, Lord.
The person that's, or the two people rather, that are having the COVID concerns, I know you said you wasn't going to ask them had they test positive or the results of any testing. Do you know if there has been exposure on their end to COVID exactly, or is that just a caution thing?
My understanding is that I've had 2 jurors test positive throughout the course of this trial. And I'd make a further record that they're the only ones within 6 feet of each other, right? They, and perhaps our civilian bailiffs, they've not been in, obviously, contact with anyone in the gallery. I don't know if maybe Attorney Opper might be within 6 feet. I don't think so, but I haven't measured it. Obviously, you're not within 6 feet of any of them. But that's a good question to ask, and I'm glad you asked that. And I wanted to make a record of that as well.
Yeah, that would be my question to it.
This, that, and the third.
I guess in reference to me, myself, just having the same concern a few weeks ago. So that would be the reason why I would want to know exactly any details that could be provided.
I'm providing all the details that I will. Again, for the record, you have not been exposed, from my opinion, because of the distance that you are away from them, and my understanding based upon my review of county policy.
Yeah, I'm not saying me myself have been exposed.
Well, that's why I asked them though too, right? I wanted to make sure they had no concerns, or if they had a concern, to see if I could accommodate it in any way. I'm satisfied that if they don't have a concern, that we can continue forward.
Have they ever, the entirety of the jury though, have they been exposed in any way?
I don't know the specifics because of the 6 foot rule, and no one has asked me to investigate that further.
Wouldn't it be smart though to see?
I don't believe that's necessary under the circumstances.
Well, if anything, just for future reference, like, what if it plays a part later on?
Well, I'll certainly take your concerns under advisement, and if I believe any further questioning needs to be done, I'll do that. At this point, I don't believe it needs to be done, but I'll think about that, and I'll take it under advisement, and if I change my mind, I'll let you know.
Yeah, I'm just saying, because if anything, it probably would be smart for the long run to make sure no one else was compromised, considering that.
Let me make a record there. No one has indicated they are compromised. I don't think we can make assumptions about how anyone who's been exposed or tested is feeling. You can be asymptomatic and test positive. You can have mild symptoms. I trust my jurors that they would report if they're not able to sit through the proceedings. And I will further advise them through the bailiffs that they are to report if they ever get to a point where they feel they're not able to sit through here, and if and so that we're advised and I can tell the parties.
Yeah, that's what I was referring to, because it went from Monday, which at that time it wasn't known.
Could have been flu, could have been just not feeling well, could have been anything, and then today is, then you kind of worry about tomorrow, Friday, over the weekend.
Mr. Brooks, I share all of those concerns, but my other concern is that we are in the third week of trial and that we should keep going until a conclusion of this matter, understanding what has happened.
All right, I just wanted to put that on the record because
I appreciate that.
it seemed like the circumstances were different when it was me.
Because we knew you were full of crap.
Are you making any specific requests given this information?
Well, I believe that
We don't care what
the
you
jury clearly all congregate together. I think it would be smart to make sure everybody is tested. I mean, that's it would be smart to do that.
I think it would be smart to make sure we delay the trial so that everybody can be tested. And don't give them one of those rapid things.
I'm not going to mandate testing for the jurors. That much I can tell you. So that request is denied.
And the grounds for the denial?
I'm not going to mandate that the jurors be subjected to testing. They're the ones who indicated they are comfortable being here. They don't have concerns. And again, I would trust them to report to me if anything changes.
Thank you, Auntie.
Too, but it still would refer back to Monday when the first knowledge of someone having an illness or a potential illness was those same questions that were asked today, asked Monday.
I did not.
Quite sure.
I certainly questioned them much more. It was a very brief. I put what I said to them on the record earlier. It was certainly not what we did here today, and the record reflects that.
Right. I'm quite sure, though, that all the jurors Monday said they didn't have any concerns as well. And then now today, someone else, same thing being said. So
I understand what you're
if it
saying.
happens again, same thing being said.
But are you making any specific requests as it relates to this topic and this issue?
Well, you denied the request that.
Any other requests?
I just feel like it's smart for them to be tested, so it doesn't come up again in the future, or potentially come up again in the future, because then we'll all be looking back and saying, well, we could have prevented something like this from happening if we had just nipped it in the bud from the get-go.
Nipped in the bud.
It's just smart to, like you say, err on the side of caution.
I appreciate that. I'm going to continue. I understand what you're saying, but given the responses of the jurors today, I'm going to continue. I'm going to base this off of their desire to continue, at least what I would interpret as their desire to continue with their service on this case.
You guys know this was the day she had her hair curly. She was so done. She was so done.
All right, then I want to talk briefly about the jury view. I did provide the parties with a proposed instruction. Before I get to that, though, Mr. Brooks, I have been thinking about your request yesterday. And I know I indicated to you that I would require you to be there. I've rethought that. I've had the overnight to really think about it. And if that is your decision to not be present for that, what I would say is this. I want you to be advised that you have a right to be at that jury view. Did you hear me say that?
Yeah, I mean, you pretty much told me yesterday about, everything that was going on. I didn't agree to or consent to it being, I was still confused about why did there even need to be a jury view. That was my whole thing. I don't see the relevancy of it, and I also didn't agree with or consent to having to be part of something that I don't see as relevant.
I appreciate you making a record of that, but did you hear what I said, that you have a right to be present for it? I've ruled that let me back up. There's been a request from the state to have the jury look at the vehicle that was recovered by the police and, of course, is alleged to be the vehicle that was driven through the parade. Did you hear me advise you of that?
Yes, I heard.
All right, so that motion was addressed previously, and I granted the request for that jury view. Did you hear me say that?
I'm informed.
All right, thank you. So with that, you have a right to be present at that jury view. Did you hear me say that?
I'm informed.
And I would like you to be there. I believe it is a piece of evidence. That's why I've drafted jury instruction 152 the way that I did. Did you hear me say that?
I'm informed.
So my question to you then this morning is, do you want to be present at the jury view of the vehicle?
I don't see the reason why I would need to be present.
Well, that's my question to you, though, is do you want to be present for it? You are the accused in this case. You're the person who the state has alleged committed these acts. The jury view will be to view a piece of evidence that frankly can't come into the courtroom due to its size, and the jury's going to be shown that. So do you want to be present at that?
For the record, I'm not a person, I'm a human being. And no, I do not consent to or agree to being present at a jury view.
All right, then I'm going to honor his request, but what I am going to do, though, is as part of that process in any event, because it's being done in a secure location, is I have ordered that I want to make a record of what's being done, and I want a visual record of what is being done. And so this jury view is going to take place in the Sally Port of the jail. And precautions are being taken so that the jurors do not know where it's at. It'll look like a garage, right? Anything that says jail within the Sally Port is being covered up. That will be verified before anyone is taken in there. They will be transported to there. I'm not sure if they'll walk or drive because it's very close. But then the sheriff's department, because as the court official, I'm in charge of keeping the record, not keeping the record, I'm in charge of making the record. It's the better way to say it. And I want to make sure that there's a record of what is done for this trial and certainly for any appellate purposes if need be. The sheriff's department, the sheriff's department is obviously charged with the security and safety of a courtroom, including the jurors. And so I have asked the sheriff's department to record. And so there is a camera that will be on a tripod that will record what's there before anyone gets there. I've instructed them to take that camera to walk around the vehicle and while it's recording to put it back on the tripod. And before the jurors and the court are brought in, once we are brought in, it will also be recorded, and that contemporaneous recording, so that will be as we will walk around the vehicle one time. That will be recorded, and then both of those recordings are going to be made part of the record. Because the second recording is for the record and has the jurors, at this point I'm going to seal it so that at least until the conclusion of the case, given the order that I have regarding the what's referenced as an anonymous or numbered jury, so that will be sealed. But what will be released to the public or be made part of the public record, and so therefore any media request, would be that recording that just shows the vehicle without the jurors in it and without the court. So, and then I plan on also bringing that back to the courtroom while the sheriff's department's going to bring it back, and then we'll show it to you at that time.
I have a question though.
Go ahead.
If I have a right to be present, then I have a right to not be present. How can this take place if I don't agree or consent to being present? How can it even still take place without me?
It will take place, sir. I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
If you don't, it's going to take place. That's how I'm going to answer that, sir. So you not going there is not going to prevent it from happening.
My Lord,
but you can forfeit your right or to be there by your conduct. And by your conduct, by not answering my question.
I didn't forfeit my right to anything.
By saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've had some time to think about that further, and I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
So why did I have to do that for when my
I'm not going to answer those questions because that would be for me to give you an explanation of the law.
No.
I'm just going to tell you that I'm not going to require a written waiver from you in order to honor your request to not be at the, or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
sir, I'm not going to go through all the law that applies to that. This is my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But your lack of consent is not going to stop the jury view. It's going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
Okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up on the record yesterday, my first thing that I said was,
have any of you guys ever sat through and listened to a lawyer define what he's saying right here and say no, correct? Here we go. This is how it works.
I don't see the relevancy of why there should even be a jury view. And that was the whole issue. And yesterday I was told about I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know what I said, and I'm telling you I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more and I'm changing my mind. I don't believe I need to take a full waiver with a colloquy with you and anything in writing. I'm advising you, you have the absolute right to be there. But I'm also advising you that if you choose not to be there, I will honor that request.
Yeah, Mo, he did. The Spanish witness that he called to testify on his behalf was one that he hit.
And I'm not going to force you. I'm not going to direct the sheriff's department to, use any type of force, if you will, or require you or get you there without your consent. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed to be interpreted by the people. The way I interpret that is I have the right or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. The relevance is that there is, in addition to the charges, there's an enhancer that has been charged as it relates to the intentional homicide charges and the first-degree recklessly endangering safety, that you committed those acts while using a dangerous weapon. I would direct your attention to the meaning of a dangerous weapon, that the legal definition that was provided to the jurors in the preliminary jury instructions, and that the jury view is related to the evidence that the state is presenting regarding the charges, and specifically the instrumentality that they allege is the dangerous weapon. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record, but I will and am permitting the jury view of the vehicle. With that, I'm going to move on to the jury instruction.
I don't agree or consent to that, Your Honor.
I understand your objection is well noted for the record. I need to keep going though on the pattern and jury.
I'm informed that you need to keep going. I'm not trying to stop you from continuing to go. I'm merely stating for the record that there are things I do not understand how they're being permitted versus the Constitution. I mean, I'm sure you're aware under Article 6, Chapter 2 about the Supremacy Clause.
You know that clause.
That the Constitution is the supreme law of the land. So how can we disregard?
Mr. Brooks, I'm not disregarding the Constitution. Here's the thing. I've made my ruling, okay? Once I've made a ruling, I do expect that even if you disagree with it, you will not continue to argue it.
It's not arguing.
We will continue on with the next topic.
I'm seeking to understand, Your Honor. It's not an argument.
Mr. Brooks, I'm not going to explain further other than what I have done, my ruling. My ruling stands. Now, I'm going to move on to the jury instruction. I gave the parties 2 documents.
May I respectfully reject that ruling and take exception to that ruling?
Your objection is noted. I'm
for the
moving
record,
on to
may I
jury.
request a legal and factual basis for your
Mr.
ruling,
Brooks,
Your
please
Honor?
don't interrupt me, okay? I give you an opportunity to raise your objections and to make your legal arguments, and then I make a ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not disruptive.
And it's interrupting and it's disruptive.
It is definitely not disruptive.
Well, if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing, and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please, please. I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone, and once I make a ruling, we're going to move on. You don't need to keep objecting because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152. I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because
you're interrupting.
You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you didn't. I was right
your
in the middle of
objection
it.
comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before we even finished.
That's not true. Okay?
You said I'm going to make a ruling as soon as you even started in about.
Mr. Brooks, I'm not going to spend hours on end making a ruling about a jury view on something I've already decided. All right, so please, I'm asking you to stop. Stop interrupting me.
You can't.
And please listen.
Just disregard the United States Constitution. Which has
I absolutely am not disregarding the
United
United States Constitution or the Constitution of the state of Wisconsin.
Are you not a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want you in this courtroom. But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this morning.
So again, you're holding me in contempt.
All right. Jury instruction 152. Has the state had an opportunity to review it?
Is that a judicial determination that I'm being held in contempt?
And I agree generally with the court's proposed instruction. I did submit kind of a counter-proposed instruction following much of the language that you had in your version, Your Honor. I just think it's maybe better to refer to this area as a garage instead of a sally port. I don't know that anybody knows what a sally port is unless they work in this industry.
Do y'all remember this part? This is going to take a while.
And instead of referring it as being in the Waukesha County Jail, I just suggested a garage attached to the Waukesha County Courthouse. I think that is factually accurate and would dispel any concerns about anybody being in custody or reference to a jail setting. I did email my proposed instruction to your clerk, and I e-filed it, but I admittedly just did that a few minutes ago. So that's why I emailed it to the clerk, because it's probably not in your queue yet.
All right, why don't we print that off so that Mr. Brooks can review that as well.
Since being called that name, what do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote-unquote jury view?
Yes. Thank you.
I accept for value in return for value this document. Now, I'd like the record to reflect I still haven't received my original copies of my filings here this morning with the timestamp.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're going to rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor?
sorry?
Respectfully for the record, may I do that?
His switch came on. That flip of that switch came on. See, this is how they happen. This is how it happens with these people. When they turn, they're like mad dogs.
You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document. That was
Reference to
accepted for value
the-
and return for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse. Those would be in the first two paragraphs. I believe the rest is the same.
So it was a couple words changed.
That's my understanding.
So it's the same document.
Let me know when you're finished reviewing it, and
I don't have to review the same document that was reviewed yesterday, accepted for value and return for value yesterday.
All right, then let me ask you this, sir. Do you have a position on the proposed instruction from the state?
It's essentially the same document. What was the significance of the change? What's the significance? Garage, Sallyport. What is the relevancy of what it's called?
State want to put on the record again the basis for the changes you.
Your Honor, to my way of thinking, it is beneficial to the defendant. It removes any reference to Sallyport, which some may recognize as being part of the Waukesha County Jail. It removes reference to the jail itself. And then in the second sentence, the pattern instruction was worded, and the court followed it. You will be taken to the Sally Port in the custody of the jury bailiffs. I just thought it was better to change that. You will be taken to the garage by the jury bailiffs. Again, removing the use of the word custody is it's factually true, but it's really irrelevant. Just to be cautious, Your Honor.
Thank you. With that, sir, do you have any?
I don't fundamentally understand that. I think everyone's well aware that I'm in custody, so how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody. How does changing the wording change what's already known?
Thank you. From my perspective, of course, when I drafted this yesterday, factually, what I put in there would be accurate because that's where the jury view is going to take place. I think changing the verbiage so that it says a garage attached to the Waukesha County Courthouse takes away any possibility that other law enforcement is condoning what is happening or somehow related to the case. It is true the location was selected due to your custodial status and being able to secure the area for the court, for you, for the jurors, etc. But it's also a controlled environment, I think, a good thing for purposes of the jury view. And so I am going to adopt the draft that was submitted by the state. It still is factually accurate. And from my perspective, again, the importance of this instruction is to tell them what is and what is not evidence, and to instruct them and to not talk during this time. They can't discuss what they see during this time. This instruction will be read while we are still in the courtroom prior to the parties in the court going to the Sally Port for that viewing, and I've already discussed how it will be contemporaneously recorded so that it's part of the record as well.
So if I was there, where will I be at?
My understanding, if you choose to be there, is you will be escorted like you are in court here now. The bailiffs would be with you. You'd be in your suit.
No, where will I be at?
I don't know exactly. That's up to the sheriff's department as to where all the parties are going to stand. Obviously, we're not going to commingle you with the state or the state with jurors or you with the jurors or the court or anything like that. My understanding is we'll have sort of assigned places and that it's only myself who will walk around. And I may not even do that. I have to think about that. But
Okay, Mark. So Mark was asking about where did he get the idea to have COVID, or is this where he gets the idea to have COVID? Hopefully we're not going over that one yet. But what I was going to tell you is that as we were watching the Chandler Halderson case, we're still doing that trial right now. And in that trial, Halderson gets COVID. So they have to delay the trial. And what I wanted to do was go back in and put those dates in and look at when that happened versus when Brooks came up and said he all of a sudden had COVID, because they were right around the same year, I think. And I'm pretty certain Halderson's case was before Brooks. I'm almost positive it was. So what I want to find out is, did he get that idea from Halderson? Because Halderson is in the same state, possibly the same prison. Think about that. If anybody knows the answer to that, let me know if you've looked it up.
the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that. if you would like. I can give the parties that opportunity.
May I add something else, Your Honor? I agree with everything the court said. I also think Mr. Brooks should understand that it will be a fair process. He's not going to be led into the room in shackles in front of the jury. It's my understanding from Captain Dussault, the attorneys for the state, the prosecution team will be in the room. Mr. Brooks will be in the room. We will be in our assigned location. It will be fair. It will match. There will be basically no distinction between how Mr. Brooks appears to the jury versus how we appear to the jury. We will be in there first. If the court's willing to allow him to walk around the car one time to look at it, we have no objection to that. And then the jurors will come in. No one will speak. They will do one lap around the car. They will leave the room, and then the parties will leave the room. That's my understanding, Your Honor.
And I will add to that, because it's been a while since I had some preliminary discussions with the Sheriff's Department on this, that if however many bailiffs, sheriff's deputies are with you, I want the same number with the state, right? And that's what we mean by it will look no different. So each party will be accompanied by deputies.
I have a question to that.
Okay.
How come none of that knowledge of how it would be conducted was discussed with me? I didn't know anything about how the bailiffs would actually do things, how certain things would go. This is my first time hearing this.
Well, we
so
have preliminary.
I don't understand it.
We have preliminary discussions at the time of the request back in August, when you still were represented by counsel. And then I had some additional preliminary discussions, if you will, internally with court staff, which included Captain Dussault and someone from the jail to talk about it and the logistics of it. And then, of course, we're having the discussion now, which is, again, why there's no jury here now. I wanted to wait until the appropriate time and then make a record of everything.
But don't you
At no time did I have conversations independently with the state. They had filed a letter at one point because they themselves had, again, my understanding, and Attorney Opera can correct me if I'm wrong, had some discussions with, to see if it was feasible. They had some discussions with Captain Dussault. And Captain Dussault is with the Waukesha County Sheriff's Department, of course, Sheriff's Department, statutorily responsible for the security of the campus, security of the courtroom. And so that would be the proper person for any party to have discussions about a piece of evidence such as this. But I did not have any discussions with the state myself. That only happened in the setting of a courtroom or when a letter was received and I reviewed it.
I haven't reviewed that letter or seen it. Don't you think that?
It was specifically addressed at the jury status hearing, at which time he was represented by Attorney Perry and Attorney Keys. It is on file, and it was addressed by this court, many of these details, Your Honor.
All right.
Many of the same details that's being discussed right now at this moment.
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole how this is all working, and then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely with bailiffs. I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly, Your Honor?
So, obviously when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine.
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are...
The security has to be left at the discretion of the Sheriff's Department.
Actually, these are leg shock devices, not shackles.
The chocolates.
Sir, the security is up to the sheriff's department. I should be careful not to overstep my bounds on that. And, you know, whatever is done, it should not be viewable or visible to the jury.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see?
That is to your benefit.
Shock.
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request, other than a statement that you're making about your lack of understanding, I need to move on with the other topics.
There is a specific request. Why do I have to have ankle shocks on my ankles to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the sheriff's department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're a shock device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room.
No BS, Opera the Chopper just steps up and says, we're not doing this no more.
Spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks?
I'm going to leave the security. I'm not going to make any specific orders. I'm going to backtrack a little bit. I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention. But we are going to move on this morning.
So I should discuss that with the sheriff?
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No, it's one document. It's one. It was 2 papers, but it's one document.
Oh, all right. Thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement, and I'll review it later. And if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, we maintain the original until it's scanned in and it's audited, and then because under the statute, once it's e-filed or into the electronic filing system and the electronic case, I believe we just destroy the documents at that point. So I don't have an issue giving you back the original, but it needs to run the normal course. My clerk needs to scan it in. I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, when we're on a break, my clerk can scan it in and then provide the original back to you, and then I'll have the electronic copy to review and address as I deem appropriate. Here you go, Madam Clerk.
I want to say to that, too, in reference to that, I actually said on record numerous times that I wanted the original copies of all my filings. I've actually said that 3 times on the record. This would be the 4th time. Every filing that
I'm going to give it back to you, sir, but I'm not required to by law.
Well, I'm just saying on record that I've asked for that numerous times.
Your statement's noted for the record. All right.
So would I be able to get all the original copies of all my filings?
I'm not going to address that any further, sir, because I am not the official keeper of the record. As to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this.
Can I have the originals for all my filings?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
All right, I'm going to move on.
I have them here.
This is taking up valuable time with the jury. We need to keep going.
Is that a judicial determination, Your Honor, that I can't get an answer to something?
I don't believe there's any other preliminary issues we need to address unless the parties have anything from the state.
Just very briefly, Your Honor, to advise the court, I have 4 witnesses here that I believe are very brief records custodian type witnesses on some video evidence. I'm hoping my direct should take 5 to 10 minutes for each of them. And then I have 2 police officers who will be testifying. There will be some physical evidence involved when those officers testify. And Detective Casey went to retrieve it and he will bring it to the courtroom. When that moment comes, do you want me to have Detective Reglin take the exhibits to the witness stand, or what is the court's direction on that?
I would like you to provide it to the Sheriff's Department bailiff who's in the courtroom, my bailiff, who will then take it to the witness stand.
Okay, Deputy Bordeaux, and yes, okay, I understand. Thank you.
All right, thank you for the roadmap for today, if you will. Anything preliminary other than the filing, sir, and other than the topics we've discussed this morning?
Yeah, I'm still wondering when I will get the copies back for the ICFs that I filed.
I can't answer that. I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know. They're not part of the record. So you'll
They
have to
should
take
be.
that up with her and make communication form and ask her for those. But I'm not going to address that any further on the record. All right, let's bring the jury up.
It's kind of funny that they disappeared. No, ICF disappeared before.
Not evidence, sir. So
They haven't disappeared before. I've always got copies. What's the difference now?
All rise for the jury.
We need to make a record.
So I have to readdress her the same thing
Readdress.
in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
Sir, as a courtesy, if you want to make a list of whatever documents you believe have not been provided copies with, I will, as a courtesy, instruct my clerk, Teresa. They're not going to be dates or timestamped other than what's in the file. They'll be from the electronic file, but you need to provide her with a list, and then I will do that as a courtesy to you. But I'm not required to do that. But as a courtesy, I will do that. And as far as any ICFs, if they weren't directed to me, then you will have to follow up with Clerk of Court Monica Paz. I don't have them. They're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
My understanding is they were forwarded to me, sir, but we'll...
So what happened to this one being forwarded to you?
Sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like
coming
you're trying
in.
to
We're
avoid
going to
it. That's
we're
what
going
it
to
seems
continue
like.
with the trial. So thank
It's
you.
like you've avoided subject matter jurisdiction. You haven't proven that on the record.
I like that, Brad. I wish I could put it up, but you said a cuss word, so I can't. But I like what you just said. Oh, my word. Yeah, Mama Brooks should be proud. Mama Woods. All right, so here's the thing. This is done for the day.
Thank you,
What
everyone.
we're gonna
Please
do
be
is watch
seated.
something else.
Thank you for your patience this morning as the court addressed some legal issues with the parties.
Watch the way you stare
All right.
at her.
If the state would, please call witness.
Thank you, Judge. The state calls Steve Schloman.
He always makes sure that the jury sees that he's not happy. You know what I mean? There you go, Brad. I can throw that one up. All right, don't go nowhere, you guys, because I got a special treat for y'all. Yeah, we're gonna close it out. We're gonna go just over 2 hours tonight, and I've decided what I'm gonna start doing on some of these is play some of the old stuff that I did. Everybody liked the Deep Brook School of Laws that I did, But here's the thing, I have to be in a certain mood to do those, to create those, and I just haven't been in the one of those moods in quite some time. So, yeah, I have to be in a really silly mood. But so what we're gonna do is we're gonna watch some of the old ones together. We're gonna watch one of the old ones together on our way out tonight. Before we do that, I would like to address a couple of things. Rhonda said she likes coffee like I like her. Rhonda, she says, I like my coffee like I like my women, hot, dark, and bitter. Rhonda, I always say that I like my coffee like I like my men blonde. That was usually the way I explain it when I go order it somewhere. Thank you again, Mark, for gifting 5 members. Thank you, Auntie A and B, for being a new member. And you guys, she's going to be on at some point tonight, so make sure y'all go over and see her channel. I had a couple of things here I wanted to touch on. Somebody asked about the 5-hour interrogation. Kristen, yeah, Kristen, we've got his 5-hour interrogation on my channel. I've got it broken up into several days, and I've even got when some other people had come in to talk to him in the jail. So check that out because I did get all the behind the scenes stuff on all of his interrogations. Some people have said they've never seen those pieces, so please go check that out. Also, the video of the vehicle being viewed. There was no video of the jury actually walking around the vehicle, obviously, because of the fact that, they're not going to show the jury. But what they did is they did a video of the vehicle before the jury came out and looked at it. So I've got a video of that as well, also on my channel. So go check that out. Naomi said, imagine being in a relationship with him. He would bring stuff up for months ago in arguments. Oh, girl, don't even make me imagine that. That's horrible. David said he saw a recent documentary on narcissistic behavior and explained why people like Brooks operate the way they do. It makes sense for me now why Brooks drove through the Christmas parade. I don't, there's no excuse for what he did, but yeah, I've kind of been picking up on some stuff too on YouTube, watching some narcissistic stuff myself as well. Cause I was like, ugh, it's just, I mean, come on, man. Come on, man. Come on, man. Here we go. Welcome to the D. Brooks School of Law Training Manuals videos. Oh, I got to pull it out. Hang on. Today we're going to talk about what you should not do ever. And we're going to show you some examples done by himself, Mr. Brooks. I'm going to fast forward it through one of these pieces,
You made
though.
reference to a number calling you back and you not looking at the number, but just answering. Do you recall stating that?
Yes.
Did you ever at any time ask who that was that called?
I just asked if it was the Uber driver.
Do you recall around what time you were subpoenaed to testify here today?
Brilliant. Brilliant questioning.
I think a letter came in the mail in July.
Please take note that Mr. Brooks is trying to take away any attention that is on the actual trial itself and confuse the witness. He wants to point all of the attention to the plaintiff, who is the state of Wisconsin. However, the state of Wisconsin is an entity. It's not an individual. So please keep watching.
And did you follow up with the district attorney's office at that point?
Yes.
Do you recall whom you spoke with?
Not quite sure the names, but
you made let the record reflect, you made a hand gesture with your left hand. Would that be referring to the table?
Yes.
Prosecution table?
Yes.
Do you see how in control Mr. Brooks is? He has taken over this witness, this testimony.
So you recall speaking to one of those attorneys?
Yes.
Do you recall whom?
I'll stipulate that Mr. Caproon's pointing at me.
Yeah.
Right, the record will still reflect.
Notice how nicely dressed Mr. Brooks is today. His shirt and Possibly his jacket might be a little bit too large on him, but just remember there's not tailors in jails.
Have you followed this matter in any way?
No.
So it'd be fair to say you didn't seek to testify in this matter. That'd be fair to say?
Yes.
Were you persuaded in any way to testify in this matter?
No.
Do you see what he's doing here? We have to make sure that the court follows all the rules. Because if they don't follow the rules, we will bring up subject matter jurisdiction.
And before you were shown Exhibit 74, and that was the call log of your phone, correct? Before.
This is probably the worst D. Brooks School of Law that I ever did. We're going to fast forward. I don't like it. Why'd y'all let me leave this up?
Myself and my colleagues here a few weeks ago.
Objection, relevancy.
Overruled.
Do you remember where that meeting took place?
Here.
In the courthouse?
Yeah.
During business hours?
Objection, relevancy.
Overruled. You questioned him about meeting with the prosecution. These are proper.
I didn't question.
Uh-oh. It seems that Mr. Brooks has opened a door. And here we're going to talk about opening a door. We don't want to do that in court. If something is not allowed to be brought up and you, the defendant, brings it up, you have opened a door.
About the time.
It's proper redirect. Go ahead, sir. You may answer.
Yes.
We discussed your potential testimony, is that right?
Yes.
Were we asking you questions about November 21st?
Objection, speculative.
Overruled. You may answer.
Yes.
We showed you that the photograph of the call log, right?
Yes.
And you had an independent recollection. You had seen that call log before because it's from your own phone.
Objection, leading.
Sustained as to the form of the question.
Had you ever seen that photograph before?
Yes.
And had you ever looked at your phone screen before?
Objection for leading.
Not leading. It's relevant, and he may answer.
It may be relevant, and the judge may think it's relevant. However, you can still object. Don't be afraid to object.
Yes.
Did we at any time give you a script for your testimony today?
Objection, asked during cross.
It's redirect. It's proper. You may answer. It's overruled.
No.
Thank you, Your Honor. That's all we have.
All right. Thank you, sir. You may step down.
Well, that one didn't go so well, boys and girls. But let's move on to the next one and see if it gets any better.
This is a 20-second clip. I'm going to ask that we play it once with audio.
Here we're going to learn about the new technology in today's world. Everyone, almost everyone, has a Ring doorbell camera. What you say and do can now be turned over to the police and you won't even know it's been done. Always keep that in mind.
Hey, I'm calling an Uber and I'm supposed to be waiting for it over here, but I don't know when it's coming. Can you call it for me, please? I'm homeless.
The voice we heard in that exhibit that we just played, whose voice is that?
Objection, leading.
Overruled.
Objection.
You may answer, sir.
It's Mr. Brooks's voice.
It's not yours.
No.
Okay.
Now, this young man was very kind to Mr. Brooks when he was out in the real world. However, we're in court now. And if you got to play dirty, You gotta play dirty.
Your Honor, I'd ask that Mr. Brooks please be instructed to remove his face mask momentarily.
Sir, would you please remove your face mask and face the witness?
Was that a question of?
The state's asked there, sir, please remove your face mask and face the
I'm
witness.
I'm confused. You made a statement about voice.
The question's been asked and answered. Please remove your mask.
What was the question?
Please remove your mask and face the witness.
Mr. Ryder, do you see the person depicted in exhibit number 75 in the courtroom today?
Yes.
Can you identify him for us by telling us where he's sitting and what he's wearing?
He's sitting at the table right there wearing a black suit and a gray striped tie.
And a mask.
And you let them use your phone, correct?
Yes.
And how do you know for sure who they were talking to?
Because the number that they had called me back and left a voicemail saying that they were the mother of the person that just called. She said something to the effect of, "Hi, you just let my son use your phone. I'm calling back to figure out what's going on." And so that told me. And I did hear the suspect use mama when they were on the phone too.
Did you follow up with the caller that left the voicemail after that?
I never called her back. No, she just called one time and left one voicemail. I did give the phone number to the police because they asked for it. So I gave them the number you had called and then told them about the voicemail calling me back. But I didn't release that to anybody else other than the police.
Do you recall keeping that phone number in your call log after that?
Oh, stop. Boys and girls, we don't want to do this. Mr. Brooks has just opened another door. In fact, I think he even opened the windows this time when he opened the door.
I believe it's still in my voicemail history, if that's what you're wondering.
Even now?
Even now.
Oh, no. Okay, the wound is open now, and it seems as if the wound's going to continue to be opened.
Yeah.
No further questions.
Oh, Mr. Brooks, Mr. Brooks, Mr. Brooks. Now, the reason he wants you to watch this and learn from his mistakes is because he does not want this to happen to you. Watch very closely at how these horrible, horrible district attorneys turn this around on him.
Thank you. Any redirect?
Please. Thank you. Mr. Ryder, do you have your phone on you right now?
Overruled. He may answer.
I don't. I gave it to a gal that let me in here. She's got it though.
Gal. That must be a Wisconsin word. Gal.
While we're waiting on that, you mentioned you checked your phone this morning to confirm that you still had the voicemail we've been talking about, right?
Yes.
Overruled. You questioned him about it. It's proper.
I'm referring to the use of the phone.
We haven't gotten there yet, sir.
I know this is hard to watch for all of you criminals out there, but you really should watch the rest of this.
Premature. You may answer.
You did check?
Yeah, I did.
If we were to provide your phone to you here today, do you think you'd be able to find that voicemail?
Objection.
Overruled. He may answer.
Yes.
Do you think you'd be able to play it on speakerphone for everybody to hear?
Objection. What is the relevancy?
Overruled.
Yeah, I can do
that. There's a way to also play it through the technology.
Objection. What is the relevancy?
Could I have a bailiff, please?
You can unplug it from the charger. It's probably
to the witness.
Oh, good. It's
Objection. What is
charged
the
up.
relevancy?
It's relevant, sir. You cross-examine him about it.
Thank you.
Yeah, I cross-examined him about the question, not
Brooks,
playing the phone.
please. I made my ruling.
So is that a judicial determination?
Go ahead. You may ask your next question, Attorney Witcher.
Please open up your phone and let me know when you find the voicemail.
Still pulling up right now.
Sure.
Take your time.
You followed instructions and turned your phone off before you came into court.
Objection.
Overruled. You may answer.
Yes, I turned the phone off before court.
Just look at those smug district attorneys. They're just swimming in arrogance. Thank you, Debbie. JPC taught me how to do all that.
Pretty much, I presume why he's loading that you're not offering the voicemail for the truth of the matter asserted, but simply to substantiate that he received a call.
Yes.
The jury will be instructed in terms of what is said in that voicemail, not to consider it for the truth of the matter asserted, but just simply to substantiate the voicemail was received.
And part of that request, Judge, would be to include the time that the voicemail was left and the number from which it came.
Objection. What is the relevancy of that?
The objection's noted, and you may ask the witness those questions.
You might as well ask about the videos too then.
We'll get to those.
How much longer do you have?
Oh, that one hurt.
With
5 minutes. Well, I don't know how long this voicemail is, with that caveat.
All right, please continue.
It's
Okay.
29-second voicemail.
Okay. Can you tell us what phone number that voicemail came from?
Objection. Relevancy.
Overruled. He may answer.
The voicemail came from so plus one or whatever. So 414-610-2153.
Can you tell us what time that voicemail came in?
Yeah.
Objection. Relevancy.
Overruled. He may answer.
5:27 p.m. on November 21st
of 2021.
Of 2021.
Objection. Leading.
Overruled. His answer may stand.
And Your Honor, at this point, I'd ask to allow the witness to play that voicemail using speakerphone. And if that doesn't work great with the audio system, then we can try the plugging in option.
Once again, the jury will only consider this not for the matter of what's asserted in that voicemail, but simply to substantiate that it was received. Go ahead.
Objection.
Noted. Overruled.
Yes, Mr. Ryder, I don't know what's going on. I'm at work. I work at Trader, and my son, that was my son who let use your phone.
Oh, sorry. I'll restart it. I was using the wrong
Yes,
mic.
Mr. Ryder, I don't know what's going on. I'm at work. I work at Trader, and my son, that was my son who let use your phone, and he's calling. I don't know what's going on. I'm just trying to see if he got the lift or what, because the guy is in a white Charger. I guess apparently the lift driver switched cars, and I didn't get the message. So I'm just trying to find out what the hell is going on. So I'm just want someone to just call me and tell me something, because I don't know.
And then that's the end of the voicemail?
Yes.
Yes, that hurt very badly. Now, we're not going to say that this is the reason that Mr. Brooks lost his case. However, it was very damning. So just remember, when one door opens, another one doesn't necessarily close. It just might open the windows. Thank you again for watching the D. Brooks School of Law training manual video.
Thanks,
Y'all come
y'all.
back.
Okay, I thought y'all'd enjoy that.
That was not my best, though. I need to clip that first part out. The first part wasn't good. Hartwell says, oh, that he looks like Richie Cunningham. He does. He does look like Richie Cunningham. He's so cute. Okay. I'm tired, guys. I've been on lives all day today. Y'all been here with me. Aren't you tired? Aren't you tired? And I've been drinking so much coffee. My word. So I appreciate you all for being here with me. We're not going to do a Brooks tomorrow, but we're going to do a Brooks on... Wait, tomorrow's Friday. I might do a Brooks tomorrow instead of doing it else, because Saturday might be tough. So maybe we'll do a Brooks tomorrow. I don't know what I'm going to do. Just stay tuned. For crying out loud, stay tuned to my channel and watch out to see when I put up a live. Sometimes I actually put the correct time on there when I set them up early. So thanks for being here with me, everybody. Thanks for all your support with my channel. I love y'all so much. And all you Brooksaholics weirdos, y'all have a blessed evening. Good night.